Good afternoon. I'm Kurt Levy, President of the Committee for Justice. Welcome to our latest in a series of Zoom panels on everything from the Supreme Court, free speech, judicial nominations, to antitrust and regulation of social media platforms. This panel is about the Texas Heartbeat Act, which allows private lawsuits against abortion providers and anyone who facilitates an abortion. Went into effect September 1st as the Supreme Court turned down a last-minute request to stop it. But the Supreme Court ruled on procedural grounds, making it clear that it wasn't ruling on the constitutionality of the Texas statute. Nonetheless, the left and the mainstream media had a fit, screaming that this meant the demise of Roe v. Wade and abortion rights. Then again, the left's been screaming about the demise of Roe, I think, at least since the nomination of Sandra Day O'Connor 40 years ago. So hard to know what to make of the reaction. Our panel of legal experts will discuss what the ruling actually means, including whether it will have an effect on abortion rights. They'll also discuss the reaction to the court's decision, including the lawsuit filed by Biden's Justice Department. And another reaction might be the possible proliferation of copycat statutes in other states, allowing private lawsuits to combat abortion and maybe even other things like gun control. But I'll leave all the details to our panel of legal experts, Ed Whalen, Carrie Severino, and Andy McCarthy. After they speak, I'll ask them some questions, and I'll include some audience questions that come through the Zoom Q&A function or that were emailed to us. So let me introduce the panelists in the order they'll speak. Edward Whalen is Distinguished Senior Fellow at the Ethics and Public Policy Center, where he directs its program on the Constitution, the courts, and the culture. He's a leading commentator on nominations to the federal courts and constitutional law, including as a frequent contributor to NRO's bench memos, where I often read him. He clerked for Supreme Court Justice Scalia and is the co-editor of 3 volumes of Scalia's work. Next, we'll hear from Andy McCarthy. He's a senior fellow at the National Review Institute, a National Review contributing editor, a prolific writer of columns analyzing the legal issues in the news. He's also a former federal prosecutor, including leading the prosecution of the 1993 World Trade Center bombing, and he's also written a bunch of books, most recently Ball of Collusion, the plot to rig an election and destroy a presidency, that presidency being Donald Trump. And then last but not least, we'll hear from Carrie Severino. She's president of the Judicial Crisis Network. She's an expert on the judicial confirmation process, co-author of a best-selling book, Justice on Trial, the Kavanaugh Confirmation and the Future of the Court. You've probably seen her many times on TV talking about the Kavanaugh Confirmation and judicial battles since then. She clerked for Justice Thomas. Like Ed, she's a graduate of Harvard Law School. And let me ask Ed to start it off, please.
Thanks very much, Kurt. Great to be here with you and Andy and Carrie. I'm going to try to set the stage for the broader discussion of the DOJ lawsuit and the issues that this act and the litigation raise by talking about how we got to where we are. Talking about the litigation that was brought by Texas abortion providers that, as you noted, resulted in the Supreme Court majority's denial of relief, a very proper denial, I believe. Talk about where that case is now. And also talk about why abortion providers are complying with the act and why there is no test case for them to try to pursue. I think this has implications for what's going to happen in the future. Okay, so let's start with the Texas Heartbeat Act, also known as SB 8. It was enacted in May. As Kurt indicated, it prohibits a physician from performing an abortion other than in a medical emergency if the physician detected a fetal heartbeat for the unborn child. Fetal heartbeat is usually detectable at 6 weeks of gestation, and importantly, had an effective date of September 1. Now, what distinguishes it from heartbeat laws in other states are the enforcement provisions that it has that are clearly designed to prevent injunctive relief. Ordinarily, those unhappy with the law can run into court and say, this violates my constitutional rights. Please enjoin these state officials from enforcing this law against me. This act actually prohibits state officials from enforcing the act in any way. So it makes no sense to run to court to ask state officials that state officials be barred from enforcing the act when the act itself prohibits them from enforcing it. So the usual path to injunctive relief isn't available. Instead, the act authorizes any private person to bring a civil action against anyone who performs a post-heartbeat abortion or who knowingly aids or abets a post-heartbeat abortion. And it includes statutory damages of at least $10,000 per violator per violation, as well as an award of attorney's fees, and has a 4-year statute of limitations. Each of those provisions is important when you understand what this means in operation. So back in July, the abortion providers finally got around after a month and a half to filing a lawsuit against various defendants in connection with this law. They named as defendants the Texas Attorney General and a handful of other Texas state officials, a single state judge, a single county clerk, and a single pro-life activist who they thought was a likely person to invoke the civil enforcement provision. They waited till another several weeks until early August, less than a month before the effective date, to file a motion for preliminary injunctive relief. And just days before the court was going to hold its hearing on preliminary injunctive relief, the federal district court denied the defendants' various motion to dismiss on various jurisdictional and sovereign immunity grounds. I'm not going to get into the details here at this point, unless folks later want me to. But the essence of it is that that ruling then gave the governmental defendants an immediate right to appeal to the Fifth Circuit, and it divested the district court of jurisdiction over the case with respect to them. The plaintiffs in the case, the abortion providers, are very unhappy with that. All the more unhappy when the Fifth Circuit denied their request to vacate the district court's order in their favor. And they ran to the Supreme Court, asking the Supreme Court on an emergency basis to enter some undefined injunction against the law. Now, and they were asking the court to rule on a matter that they never presented to the district court or to the Court of Appeals. The Supreme Court, by a vote of 5-4, denied that request for emergency relief. The per curia majority consisted of Justices Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. And they explained that the abortion provider's request presents complex and novel antecedent procedural questions on which the abortion providers had not carried the burden. They made clear they were not addressing the constitutionality of the act. They instead were looking to the question whether the abortion providers had shown that they had any entitlement to relief against these defendants. They spelled out that federal courts enjoy the power to enjoin individuals tasked with enforcing laws, not, as so many people mistakenly suppose, the laws themselves. We often speak in shorthand about enjoining laws. We actually enjoin defendants from enforcing laws. And because of the abortion providers hadn't shown that the named defendants can or will seek to enforce the Texas law against the applicants, the court denied relief. Now, there were dissents by each of the 4 dissenters. What they have in common is that none of them explained what relief they would order against which named defendants in a way that would somehow prevent the millions of non-party individuals from enforcing the act in hundreds of Texas courts. In other words, they failed to show how they could possibly enter an order that would give the abortion providers relief from the harm that they claimed to face. Now, one of those justices in dissent, I'm sorry to say, was the Chief Justice, often a hawk on federal jurisdictional issues. He just seemed to say, well, maybe we could punt now and buy time until we figure out what might be done. Justices Breyer and Sotomayor and Kagan were at least as bad. Kagan talked about how this case somehow shows why the so-called shadow docket is bad, but here it was the abortion providers who are rushing to invoke the emergency relief from the shadow docket, and I think it was entirely proper for the court to deny that relief. Again, the court made clear it was not ruling on the constitutionality of the act. Now, where is that case now? Well, the Fifth Circuit will be hearing oral arguments soon. I don't believe it's declared a date yet on the jurisdictional questions, sovereign immunity questions involved there, and it'll proceed down that path soon. I want to address now very briefly to finish up, why is it that abortion providers are complying with the act? Well, first of all, there's massive potential liability for post-heartbeat abortions done now if Roe and Casey are overturned. And as you know, the pending Dodds case in the Supreme Court, which should be decided by June, presents the court a golden opportunity to finally inter Roe and Casey. As I mentioned, it's $10,000, at least $10,000 per violation per violator. You do the math. You understand that an abortion clinic, in addition to being liable itself, probably has 3 or 4 individuals involved, at least in the average abortion. So you're talking about $40,000 to $50,000 of liability per abortion. It's tough to have a business model that runs on that basis. You have 4-year statute of limitations, so the potential plaintiffs don't need to file right away. They can wait to make sure that Roe has been overturned. And again, understand that Roe and Casey do not invalidate the act. They instead provide a legal basis on which the court might enjoin named defendants from enforcing it. They provide, Roe and Casey right now provide dubious protection in the long run, as without injunctive relief, a claim for unenforceability of the act is very weak. In other words, if Roe is overturned in June, I think there's a very, very strong claim that private civil enforcers could pursue the massive damages awards against the abortion providers for any abortions that were done between now and then. And finally, a test case wouldn't achieve anything. I mean, we could talk about the mechanics of this, but at most, if a so-called test case were somehow filed now, it would probably involve collusion in any event, because have in mind that the abortion providers would be the defendants. But at most, you might get injunctive relief against a particular plaintiff. That does nothing to protect you against the millions and millions of other plaintiffs down the road, and does nothing even with respect to the particular abortion that might be subject to the test case to relieve you of liability for that. So right now, the matter has shifted to the Department of Justice's recently filed lawsuit, and I'll turn it over to Andy for more on that.
Well, thank you, Ed. Thanks, Kurt. It's great to be here with Ed and Carrie. I want to direct my remarks mainly to set up what the Biden Justice Department is trying to achieve through the prism of what I think are the important public policy issues that are vindicated by the jurisdictional issues. There's been a lot of poo-pooing of the fact that in connection with the discussion of the Supreme Court decision that they're dodging Roe by procedural means, and I just want to stress that I think that these procedural hurdles are significant and they serve important public policy interests. The Biden Justice Department seems to be taking the position that in enacting its laws, a sovereign state must be deemed to provide for a challenge to the law's validity in federal court, and further, that every right must be deemed to have a judicial remedy, even if the law doesn't expressly provide for one. There's no doubt that the Texas abortion law, as Ed described it, was structured to make it difficult, if not impossible, to challenge pre-enforcement. This was done to forfend what invariably happens in cases involving abortion restrictions, usually a federal court, at the behest of activists whose standing is often dubious, issues an injunction that prevents the law from going into effect. Besides the fact that these litigations usually take a long time to make their way through the system, this practice has perverse effects. It means that the default assumption in a sovereign state is that the laws enacted by its elected representatives are not binding. They are presumed to be invalid unless courts, eventually the federal courts, say otherwise. It turns our system of governance on its head. With respect to virtually all other areas of law, we are supposed to presume that legislative acts are valid and people should follow them. Legal challenges are supposed to be the exception. The challenger is required to demonstrate that the challenger has a right to sue and that there is strong reason to believe that the presumptively valid legislative act is actually invalid. In abortion cases, however, the default idea seems to be that the state's laws are invalid until proven otherwise, and people do not need to change their behavior to conform to them. The Texas fetal heartbeat law was designed to ensure that the state's abortion laws are entitled to the same presumption of legitimacy as other laws. To do that, the law needed to go into effect. To prevent courts from stopping it from going into effect is exactly what the legislature tried to do in the way that, that they structured it. Consequently, as Ed described, the statute provides that it cannot be enforced by the usual law enforcement arms of the state. And that's the reason why, as Ed further described, that legislation, there really was no case, which is why that case went nowhere, and there was no, the predicates for jurisdiction didn't exist. I'm jumping ahead in what I was planning to say because I don't want to be repetitive of what Ed's already described. Since no one had taken any action, and indeed most of those sued were state officials who were barred by the statute's own terms from taking action, there was no case, no controversy, no basis for jurisdiction, and no standing to sue. And in the end, I think, as Ed also described, I thought the most disconcerting aspect of the Supreme Court ruling was that it was not a 9-0 rejection, because there simply was no suit. And in fact, I think Ed mentioned the Chief Justice's dissent. I thought he effectively conceded that the majority was correct on the jurisdictional issue, and he appeared to just be groping for a way to get at the case, to not get at the case, because there really was no case. Plainly, what the pro-abortion side is most alarmed by is that because the law enacted by the people's representatives went into effect, it is having the effect that presumptively legitimate laws have, even when they are not being actively enforced. That is, it is changing the assumption that abortion is legal and readily available in the state of Texas. There is a law that says it is not, and thus far abortion providers have resisted challenging it. That no doubt means that fewer women are seeking abortions, and providers are thus far not accommodating any who may be seeking abortions. I don't expect that to continue, by the way. To my mind, it's a welcome development, but I imagine that eventually, especially if the litigation that we're discussing and that the Justice Department is bringing doesn't work out, I think that you'll eventually get a lawsuit by someone at least who aids and abets an abortion provider, or a lawsuit against someone who aids and abets an abortion provider, if not a lawsuit against an abortion provider. But for now, the law is having the intended effect. It's changing people's behavior. So prodded by abortion activists, the Biden administration, the Justice Department have now filed their suit. As a matter of common sense, the federal government has even less of a concrete injury for standing purposes than the abortion providers. At least the abortion providers can say that they stand to be sued if they engage in the conduct that the statute prohibits, which of course is their profession. The Justice Department purports to be bringing its equity suit under the 14th Amendment. It seeks an injunction on behalf mainly of women whose court-invented Roe Casey right to abortion is said to be chilled. The chilling, the Justice Department urges, exists because the Texas law is on the books under circumstances where it has not been subjected to court review, as if court review were part of the ordinary process of enacting law. I think the major flaw in the suit is that there is no provision in federal law that specifically greenlights a third-party lawsuit in equity to vindicate the Roe Casey's so-called right. The Justice Department generally takes the position that the government has no authority to enforce rights of citizens against a state unless Congress has been clear in permitting such suits. And yet it wants to proceed with this suit under circumstances where it runs into the same problem that it usually complains about. The Justice Department is basically saying there's an abortion right, so there simply must be a judicial remedy vindicating that right. And secondly, if we can't file a suit, then no one can challenge this law without first violating it. I think the answer to those 2 points have to be, first, not every right has a judicial remedy. And secondly, if a law cannot be challenged until a court can evaluate it in the context of a concrete case of violating the law, so what? So I'll leave it there and pass it along to Carrie.
Thanks so much, Ed and Andy. That was a great setup. And I'm just going to talk about some of maybe the implications going forward for Dobbs, for potential copycat litigation, and for other things down the road, court packing. What are some of the downstream effects that we might see of this case? First of all, what is the implication of on Dobbs of this Texas case? I'd be curious to know if the people who are writing this really had that in their mind. But by May, I think it was clear that the court. Actually, I have to look back and see when they accepted Dobbs, but it may well have been clear the court was going to be hearing the case this term. So the timing is interesting because the case was, the law went into effect right as we're ramping up to the Supreme Court term that is actually going to decide the question of the merits. The emergency appeal, as Ed explained, did not address the issue on the merits, even whether the Texas law is valid, let alone the underlying question that is the elephant in every room when we're talking about these things, which is Roe versus Wade, is Planned Parenthood versus Casey, are they good law? And so on the merits, does it have any implication for Dobbs? Not at all. The case, the decision that the court rendered had everything to do with the procedural details of this case and nothing to do with that underlying question. However, I do think there are some implications. There's things we can learn from this decision, and there may be implications of this case on Dobbs. So, for example, the first one, which I think it was, mostly good news, is the court has now gotten its first taste of what it is going to be only getting more of as this term progresses, which is the intimidation that we see surrounding any of these major issues when they come to the Supreme Court. It's a pattern that unfortunately has been increasing over the years, and I think is going to reach fever pitch this year. The attempts to block to bully the justices really into ruling your way. And we see that sometimes in this sort of outright protests. In fact, the day that the reply brief in Dobbs was submitted, there actually were protests at Brett Kavanaugh's house, which I was grateful to see even a lot of people on the left saying, okay, that is a bridge too far. It's one thing having a protest around the Supreme Court. It's another thing taking it to someone's home and family, especially someone with young children like Justice Kavanaugh. So that is a level of intimidation we should never stand for, but it's something we see. We also have seen intimidation in other areas, and I think will happen in the Dobbs case as well, in terms of threats to the court as an institution. Famously in the New York rifle and pistol case a few years ago, there was a brief signed by Senator Whitehouse and several of his colleagues that more or less suggested if you don't declare this case moot, and mootness was a real question in the case, but if you don't get rid of this case on this procedural grounds, then we may have to take action to reform the court. And at the time it was clear he's talking about court packing. This is something that I'm sure that we've only had a few members of the court that have spoken out about it, but people, including people like Ruth Bader Ginsburg, Stephen Breyer, Amy Coney Barrett spoke out about it recently. Clearly is not something the justices think is a good idea. And I think most politicians in the country, even those who publicly support it, recognize what a disaster that would be for the Supreme Court in terms of triggering a quid pro quo, one-way ratchet of just each party, every opportunity they got, adding more justices. It would, if anyone is worried about the court becoming a political football. That would just cement it in stone that the court is just going to be the constant football of adding new members. And it's not, it is something that unfortunately has happened before in places like Chavez's Venezuela. We don't want to be following that lead of all places. So the idea that threats would be made to the court of we're going to undermine this institution through court packing is something that in that case happened even through a filing to the court, which was really egregious. Certainly happens all the time rhetorically in the media. And I'm regularly asked this by journalists, well, hey, if the Supreme Court did strike down Roe in Dobbs, or, you know, in some having to do with something that had to do with this Texas case as well, isn't that going to trigger more calls for court packing? I think my answer would be, yes, if it's raining, it's would trigger calls for court packing. If it's Tuesday, that triggers calls for court packing. They don't need an excuse. They will call for the court to be packed anytime they think they have an opportunity, in season and out of season, and they're going to keep doing it until they think they have the votes to do it. And the only way to really stop that dead in its tracks is to make it so obvious that it is so politically toxic that they stop doing it. That's what happened after FDR attempted it. You realize that even his own party wasn't supporting him in this, and Americans across the board rejected that. So I think that's something that we would like to make very clear. And I would hope that the members of Congress would have enough sense to realize that's a bad method. But it's certainly going to be part of the panoply of intimidation of the court. I would say one other implication this has maybe for Dobbs is, if anything, this should serve to a reminder of the court that as strong as the temptation may be in Dobbs, or frankly in any other case that deals with these really high-profile, third-rail cultural issues, the incentive I think the court always has, and in boring cases as well to a certain extent, is let's come up with a narrow decision and move on and decide as little as possible. You know, the less we do, the better. I don't think that's necessarily what my judicial philosophy would always be in a case, but I can understand the temptation. In the Dobbs case, the temptation is particularly strong because they know there's going to be a huge political fallout if they overturn Roe versus Wade. I think the fact of the matter is, in this case, just illustrates there is going to be huge political fallout either way. It is not, you don't get to dodge that bullet. And in fact, if you refuse to address the issue head on in that case, and I think that case is very well set up actually to make it very hard in a principled way. There's no like, oh, well, we can say at least Roe versus Wade doesn't cover 15-week ban, which is what's going on in Dobbs, but maybe we'll revisit later whether it covers other ones. There's not really a middle ground that you can go to without blatantly making up a new legal standard, which might be something that a few justices of the court I can imagine doing, but it's very hard for me to imagine, particularly the 5 justices who are really committed to textualism and originalism, doing that type of blatant judicial legislation. But this illustrates that, hey, even if you didn't go all the way in Dobbs and you tried to make up a new standard here, it's not going away. The next case that will come up, then you think it was annoying having to deal with this emergency hearing in the Texas case. You're going to probably have 2 or 3 more emergency appeals, and then another actual on the merits case that's going to come up. You're going to have other states, and we know that there's a whole range of different issues. There's actually 2 cases on petition right now to the Supreme Court from, I think it's Missouri and Tennessee, that deal with both bans at various levels. I think both states have bans that could either be at 6 weeks, or if that gets struck down at 8 weeks, or if that gets struck down at 10 weeks, or if that just cascading lines, or discriminatory abortion bans. So banning abortion that discriminates on the basis of race, on the basis of sex, or on the basis of Down syndrome status, all of which are real serious issues that people do have abortions, and it's very easy to demonstrate. So the court is going to have to deal with this issue. The only actual way to get this out of the Supreme Court, to stop some of those abortion distortions, which Andy alluded to, where regular standards of laws, the regular legal rule of law that we apply in any other case, somehow we have an exception, and except if it's dealing with abortion. No area of law should have that. We should be applying the law fairly across the board. And unfortunately, that has sprung up around abortion litigation. It would be much healthier for the rule of law to have that out. And of course, at root, that's because abortion is not actually given by the Constitution to the federal government to address and to regulate. It is something that is reserved, along with everything else that's not expressly mentioned and discussed in the Constitution to the states. And so in order to be faithful to the constitutional system, it gives us the best result, which is to get that out of the courts. It means it would go back to the states. Look, that's not what pro-lifers would, doesn't give them everything they want either, because then you've got states like California, New York, we're going to have abortions up to the minute of birth. And frankly, you've got states that might want to have laws like you can leave a baby who survives an abortion to die on the operating table. So you can have states that have a whole range. You're going to have Texas. You're going to have states that look like Mississippi. You're going to have states that look like Georgia. It's going to be a range, and that doesn't mean that it's given the pro-life movement. It handed them an achievement of their goals. What it's really done is said, now this is a fight that's going to go back where it started and where it should always have been under our Constitution, which is to the states. And then the Supreme Court can simply say, you know what, off our plate, we don't have to deal with it. So the correct legal answer also, I think, in the long run, it's a ripping the Band-Aid off kind of thing. It's going to be painful at first, but anything is going to be painful at first, but then it takes it off of their plate. And then finally, just to the question of copycat laws, that's something I actually hope we don't see. And at this point, as effective as the Texas law has been in terms of successfully being able to go into effect, despite some of the legal problems that have faced other abortion regulations at the state level, I think I'm concerned that judges in general, I think, are going to walk into a law that is designed to avoid their jurisdiction with a chip on their shoulder. I think you saw a little bit of this in Chief Justice Roberts' own dissent from that thing. I think to go into a law and looking at a law saying this law is trying to avoid judicial review, at least at this preliminary level, I think that probably doesn't give it its best grounds for support by a judge. And I think that actually makes them potentially more liable than a more straightforward abortion law. On top of which, presumably Dobbs is going to be assigned shortly for oral argument. It could be as early as the last week of November that it gets heard. And barring something truly strange, it would probably be decided in June, right? So we will know by June what the underlying question is. If the result in Dobbs means Roe versus Wade is overturned, we don't need to make laws that have these procedural workarounds anymore. States could go down a much more traditional route and decide, okay, let's not have to worry about deputizing various other individuals, and let's just go through the straightforward approach. Just as an aside too, and partly to my husband recently had an op-ed pointing some of this stuff out, so I'll bring his work in, that the idea that you're deputizing other people is something super novel in law actually is not accurate. There are several other federal laws that do that, from the False Claims Act to civil rights housing laws that allow testing groups to go in and actually help reward them for finding violations of federal law. So it's not as novel as the press is making it out to be. Nonetheless, I do think it would make more sense for states to be able to take a more direct approach. I think the other reason that it's better just to not proliferate this type of law right now is I think it makes more sense to focus on Dobbs, where this is a real question. What the left is attempting to do with this case is part and parcel of their general scaremongering and hyperbole and distortion of what the facts really are in a case, in order to try to make a rhetorical point. So while the Supreme Court is addressing Dobbs, it makes more sense to actually be talking about, well, okay, they're looking at a case that has a 15-week ban, at a point at which women are much more at risk from abortion, a point at which the unborn child can feel pain, a point which is farther along than most European, I think most means like 47 out of 50 European democracies forbids abortion in an earlier phase in this. It makes more sense to discuss Dobbs on its actual terms than to allow people to start talking about a different law and try to switch the conversation. I've already heard, things that are really detached from the reality, even of the Texas facts, where you're having people like Claire McCaskill saying, well, they're going to outlaw in vitro fertilization and all these things. That's not what's on the table here. That's not what's being discussed in these cases. And I don't think it's going to help to give more opportunities for the media and for Democrats to distract from the actual facts of what the court is really considering. In terms of whether there is going to be a lawsuit under this case, I'm not sure if there will be. Obviously, at some point, as I think Andy is probably right, that there may be reasons that some abortion clinics will restart their activity. I'm not sure what their calculus is going to be on that. But even if they do, given the 4-year statute of limitations, it seems to me that if someone wanted to bring a suit, it might make more sense to wait until they know what the ground rules are under Dobbs before doing so. And they'll be well within their statute of limitations before that is figured out. And I think that also then prevents this from kind of leapfrogging as the court is considering Dobbs, allow it to consider the cleaner, kind of better vehicle, I think, for addressing the questions of Roe rather than leapfrogging it in a lawsuit. But there's ample time to bring those lawsuits within the statute of limitations if abortions in Texas did resume. So with that, I'll hand it back to Kurt and we can discuss.
Carrie, you referred to them going all the way in Dobbs, and I guess you meant explicitly overturning all of Roe v. Wade. A, do you think there's any chance they would do that? And B, would it arguably be dictum, given that they really only have to rule about the 15-week limit?
Well, I think one of the unique things about the Dodds case, maybe in terms of cases that's been brought on this case, is how could it be dictum? Because it's hard for me to imagine a situation. Yeah, they don't have to. They could make up a rule that says, well, actually, you can prohibit abortions after the first trimester, or there's a whole lot of other rules you could come up with, but they would all be legislative type balancing rules. Frankly, some of them might match where the American people is more than either a outright abortion by a ban or a Texas type law or the current situation, which is the under Roe and Casey. But the case is set up such that it's hard to imagine, Roe and Casey clearly wouldn't allow flat out prohibition on abortion before viability, and under no medical interpretation is 15 weeks post viability. It looked like Ed might have a comment there too.
Yeah, well, just to add to what Carrie is saying, the threshold question in the case is what is the standard of review that applies to the abortion restriction. So it's absolutely not dictum to decide what that standard of review ought to be. And I entirely agree with Carrie that it's difficult to see any off-ramp in any way that the court could coherently decide this case without teeing up Roe and Casey for overturning. And if not now, when? I mean, this is a case that screams out for it. I think we ought to have a supermajority to rule to overturn Roe in a way that is as durable as could ever be. And so, I think there's no excuses for timidity here.
Well, no excuses, but let me ask you all, wouldn't it be somewhat understandable if the 5 justices that we have in mind were a little bit intimidated? I mean, I thought that was sort of the biggest takeaway from the Texas ruling, was just that, those 5 had enough courage to even make a procedural ruling that allowed the law to go into effect. But, I also, to be honest, wonder whether when push comes to shove, they will have the courage to overturn Roe v. Wade. Am I hearing you all say, yes, you think they will have the courage?
Well, they're better, but I would say it's not 5, it's 6. There ought to be the Chief Justice should not want a 5-4 ruling on this. I can't understand how he gave a 6th vote in the Bostock case, but the only possible explanation is he didn't want something 5-4. No, we have every right to expect a 6-3 ruling. Indeed, Justice Breyer, looking to international law to see what the standard ought to be, ought to, at the very least, write an opinion concurring in the judgment, saying that a 15-week ban is perfectly okay. Of course, it ought to be 9-0, but the ideological commitments of the liberal justices make that implausible.
I would just add to that I'm a little bit more concerned about the caterwauling on the right than the left, frankly. I think the left is going to do what the left always does on this issue, which Carrie outlined very persuasively. What I worry about is we have a lot of people on the right who are basically saying, you know, look, Biden's presidency so far has been the opposite of a smooth sail, let's say, and particularly with the botched pullout of Afghanistan, a lot of things have come to a head, and it almost looks like a perfect storm of failure, at least at the moment. And these things can change pretty quickly. But what I'm beginning to hear a lot on the right is that politically speaking, the worst thing that you can do is wake up the left by throwing out Roe and Casey in Dobbs, and basically then having the states, as should be the case, wrestle with what they want to do with abortion, with their sense being that the politics of that is better for progressives than for conservatives. And I have to say, after nearly half a century of this, I just think this too clever by half stuff is, you just want to shoot yourself over it. I mean, you know, look, their job is to decide these questions, and there's always a million rationalizations you can come up with to dodge things that are difficult. But I think that, you know, this issue is teed up. It needs to be decided. As Carrie said, it's like ripping off the bandage. It'll be painful at the beginning, and we can't actually predict what is going to happen afterwards. There's too many moving pieces. There'll be action in every state. But I just think a calculation about the politics based on what might happen in the 2022 midterms, which will then lead to what might then happen in the 2024 election, I think we got to knock that stuff off.
I agree.
This case has just got to be decided on the main issue.
I agree totally with you, Andy, and I think you know that pro-lifers will rightly feel abused if people are always making these political calculations about, oh, not now, not now, not now. Well, if not now, when? I was a law clerk for Justice Scalia in 1992 when the court had a chance to overturn Roe and instead imposed Planned Parenthood versus Casey. And I know that there are prominent Republicans who thought, oh, good, lucky thing that happened, because you know what would have happened otherwise? Well, Bill Clinton would have been elected president. Yeah, he was. So, I mean, the people are making political excuses or playing to this. You know, the court has got to do its job. It's time to overturn it. It's long past time to overturn it. And again, we need to be setting our expectations high. I mean, I am not, you know, the Chief Justice does not have some sort of free pass to vote the other way on this. His jurisprudential commitments ought to take him in the right place here. We have every right to expect him to be part of a 6-justice majority.
Well,
And if I can just add, I think even if, and I think as both Ed and Andy have commented, I think it's actually very questionable whether it actually would be good politically for the GOP to not have Dobbs there. I think it would also entail some serious discouragement of the many people who have just worked so hard to ensure that we have judges who are voting based on the law and the Constitution and not based on political concerns. And so what worse could you do than actually make a calculation based on political concerns? So even if they were correct that, oh, it's going to give Republicans a bump in 2022, that's a very short-term trade-off for a major violation of your oath, really. If you are making a political calculation, whatever the political calculation is, rather than looking at what is the legal result that is mandated by the law and the Constitution here, you're doing it wrong. And no good result is going to ultimately follow from that. Even if you think you might gain a short-term gain, as Ed said, you might think you're even gaining a short-term gain that turns out not to even happen. Bill Clinton was elected anyway, so right. there's no guarantee, and it's be very foolish to sell your soul judicially on grounds as weak as that.
Getting back to Roberts. I certainly share Ed's expectation. I guess I'm less confident on what he'll do, given his tendency to, I'm trying to remember the word that Andy used, but basically, try to split the baby in some unconvincing way. Does anyone?
Very bad metaphor.
Yes, yeah, no, you're right. And you know what? My colleague Ashley has warned me for a long time, do not use that metaphor in the context of abortion. And sadly, I forgot. So I apologize. But in any case, am I unduly pessimistic about Roberts? Not in terms of what he should do, but what he will do.
Can I just add on to your question, Kirk? Because I think this is Ed and Carrie are much better to speak to this than I am. But I've also wondered how much does it factor in that he's the Chief Justice, and therefore if he's in the majority, he gets to either write it himself or assign it. How much does that play into this?
Carrie or Ed?
Well, that's obviously one attractive reason to join a majority. And the chief typically does assign himself a lot of these really exciting cases. So, you sort of wonder how him writing it looks different than I think it's clear the Chief Justice writing would look different than a Thomas writing it, would look different than a Kavanaugh writing it, would look different than a Gorsuch or an Alito writing it. So I don't know, that's interesting, although he still would have to keep all six on. You wouldn't want to, I don't think for the purpose, I would hope that for the purposes of getting six on, you wouldn't write the opinion and then get trigger a concurrence that then ends up actually having maybe more votes than the majority opinion itself. Ed, what's your thoughts?
Well, I guess I'd point out first, as I did in I think a couple of bench memos posts last month, that what the Chief Justice has written about principles of stare decisis cuts very much in favor of overturning Roe here. Again, his broader jurisprudential commitments ought to be there. Look, as he put it in his Obergefell dissent, just who do we think we are? Just who does the court think, who do the justices think they are, continuing to usurp this matter for decade after decade? So look, I think I think he would probably write it himself, and I think he would write it in a way that got 6 votes.
A lot of people are saying that Texas's strategy was either brilliant on the right or on the left evil, but there are also some people on the right who are concerned that it could come back to bite us, that maybe it is too clever by half, in the sense that the left may try this on gun control or other issues. Basically have a gun control law that evades review because it's done through enabling private actions. Anyone have any thoughts on the likelihood of this being repeated on other issues, and whether we should be worried?
Sure. Well, look, I think what makes this law so effective and why abortion providers are complying with it is precisely the prospect that Roe might soon be overturned. Oh, sure, there are some other features of the law that could invite overly aggressive plaintiffs to try to enforce it. But it's really the vulnerability of Roe right now to being overturned that gives this special force. You're not going to have that with respect to gun rights or these other areas. Besides which, in so many respects, the left has already pursued very aggressive actions in these areas, whether it's farming things out to civil rights, so-called human rights commissions or civil rights commissions that can go after florists and bakers, to no end. So I don't think the concern that the left will copy this provides any reason not to do this. There may be other reasons not to, but I don't think that's one.
And on that question, the backstop is the Second Amendment, and I think it would be if they're trying to use it to go against activity that's clearly protected by the Bill of Rights. I think that would be our protection. So,
yeah, I would only add to that every one of these calls is always a cost-benefit analysis, And every day there's fewer abortions in Texas. That's a good thing. And if it means that we'll have to deal with more of the same of what progressives do anyway, then we'll just have to deal with it.
I will note Carrie's remarkable assertion that a constitutional right that's actually in the Bill of Rights has greater standing than one that's made up out of whole cloth. So although didn't Joe Scarborough the other day refer to abortion rights as one of our enumerated rights? So
yes.
So perhaps people have forgotten.
I think he meant emanated rights.
But, you know, it's certainly unlike gun rights, it's a politically correct, it's a woke right, and that may be the best thing that it has going for it if it is going to survive. But, you know, again, I found the reaction to this particularly hysterical. Again, the left has been hysterical about Roe v. Wade for decades now. But do you think in some weird way that hysteria makes it easier for the court now to chip away at or overturn Roe, in the sense that people have already said the apocalypse is here, which makes it a little less shocking when the apocalypse actually comes?
I think yeah. You know, one of the things we often arrive at, especially during presidential campaigns, is that for all the heated rhetoric on this, there's not a lot that the federal political system really can do about abortion other than judicial selections, because of the trajectory that Roe put us on. And I suspect that if we get the decision in Dobbs that we ought to get, and abortion gets basically sent back to the states to be decided politically and through the democratic process in the states, we may be overstating what the earthquake turns out to be. I think once you get Roe out of federal judicial selection, out of federal law, and send it back to the states, there'll be a lot of gnashing of teeth at the beginning if this happens. But I think it may pipe down faster than people realize.
I'm going to try to ask a few audience questions here. One is, I guess, parallel to the point about worrying about the next election. Audience member asks, several pro-life activists have warned about trying to overturn Roe too quickly, and have suggested instead chipping away to avoid a big defeat in the Supreme Court. And basically the question is the Texas Heartbeat Act, with its roughly 6-week limit, a case of moving too quickly that may blow up?
Well, again, it's been 50 years, so I don't know how quickly it can be too quickly. And Dobbs is before the court. Dobbs is the case the court will decide. But again, I mean, while Dobbs is a ban in 15 weeks, I think it compels the court to address whether Roe and Casey should be overturned. And I think it would be a terrible blown opportunity for the court not to address that question straight up. And I just don't understand. I mean, the pro-lifers, and the question is right that there are some who think that we don't do it in this case. They're always going to have excuses not to do it. When are we ever going to do it?
Any other thoughts?
Again, in this case, one could imagine in another case a stepwise process. In the way that Dobbs is constructed, it's just very hard to there's not a lot of middle ground there. If they're going to uphold the law, it's not we'll uphold it for 15, but we're reserving the right to not say 13. To do that, you have to rewrite Roe and Casey. And if I would hope that we don't have 5 justices or 6 justices who are interested in straight up rewriting the law. And I think now the concern about that Andy pointed out about it creating a ripple effect in the states. I think he's right. Actually, this could calm down some of the the political hysteria simply because it diffuses it somewhat. And even Ruth Bader Ginsburg herself had made those comments. She worried that Roe, by taking it out of the states, actually kind of ossified and made permanent that divisiveness, because there was no way to actually address or come to compromise positions. Where most Americans are is somewhere in the middle there, and you could, at a legislative level, they can make those decisions and weigh and balance different things in a different way than a court is able to do, chiefly because in this case, the court doesn't even have any legislative text that it's going with. So the justices shouldn't be the ones trying to balance, medical testimony and stories from different perspectives. That's not what they should be deciding anyway.
Like you, Carrie, I had the odd feeling that Andy was reminding me of Ruth Bader Ginsburg.
Well, I can't help but point out that before Roe, abortion was not the dominant, most divisive issue in the nation. So I think Ruth Bader Ginsburg is right on that one. Here's an interesting audience question. Can a post-abortive woman who regrets her abortion, or maybe even more feels pressured or coerced, can she sue under the Texas law?
I believe she can. There aren't, my recollection, you guys correct me if I'm wrong about this, but my recollection is that there is a bar against a suit being brought by a man who impregnates a woman in a rape or incest situation, and that's explicitly stated in the law. Other than that, I don't remember off the top of my head there being other explicit bars against people bringing suits.
Yeah, I think that's right. There's a bar against a suit against the woman getting the abortion. She's not going to be a defendant, but there's nothing
Right.
I believe there's nothing that bars her from being a plaintiff.
That might be a very very sympathetic suit. Another caller wants to know about the health of the mother exception and worries that wants to know basically if that survives, will it swallow any victory that's achieved in Dobbs?
Well, that's a very good question. And indeed, if the court did allow the expansive health exception that the companion case to Roe of Doe versus Bolton has been understood to confer, one that talks about familial health and economic health and all sorts of things, it would indeed be a loophole you could drive a truck through. I can't imagine a court would overturn Roe and Casey without making clear that it was also overturning that loophole.
I'm not sure if the questioner was thinking of the Texas law, who does have a medical emergency exception in it, which I think was probably written that way so as not to be interpreted to be the sort of economic well-being and mental health and all these other things in there. There certainly are cases where there's medical emergencies, although I think from a moral and ethical perspective, if you're trying to preserve someone's life, I don't think it normally would be. In some of those cases, I'm not sure that would be necessarily the type of abortion that would trigger those anyway. But bottom line is the Texas law does have an exception for medical emergencies, but I think that's going to be significantly more narrow and would actually have to do with true risk to someone's immediate, because they were emergency, and true risk to someone's actual health.
Yeah, I thought it was interesting. I thought it was interesting that the law has a definitions section, and it didn't undertake to define medical emergency. So I guess that's a matter of Texas law, and it is the kind of thing that a court is going to have some leeway with.
Yeah, and there's nothing to stop the court from reading in a broad exception, and I guess that's one way the court could compromise if it so desires, although I'm certainly not suggesting that would be a good idea. Unfortunately, we've run out of time. I always feel with these things like we could go on a lot longer. It's such an interesting discussion, but I guess I'll stop and thank our esteemed panelists for making this such a great and interesting panel. And we do these panels frequently, so tune in again soon for another interesting topic. Have a good day and thanks for tuning in. Bye-bye.
Thank you.